Welcome back. We're discussing a whole host of online internet censorship bills that the government is bringing down our path. One recently that we just discussed, C-11, just recently passed the Senate with amendments. Joining me for that discussion is Joanna Baron, Executive Director, the Canadian Constitutional Foundation. Joanna, I want to wrap up this discussion on C-11 because sadly there are other attacks, I guess I could call them, on constitutional freedoms. But with C-11, the Minister Rodriguez, who is our cultural minister, stated that any of those amendments that came from the Senate, because when they pass a bill in the Senate, they can attach amendments and give some direction before it gets royal assent. He stated that any amendment that has any meaningful impact, he's just going to ignore. So if any amendment from the Senate were actually should change some of the meat and potatoes of the law, not interested. He's not going to do it. I thought that was strange and a really affront to democracy. It's very shocking.
Yeah, it's shocking. I can't really tell or speculate about what the government's rationale is, but they really have chosen to dig in their feet on this particular bill. And as I say, it's not about a conservative or liberal issue. Across the spectrum, there have been concerns about this. And in the Senate, which is part of the government, and the Senate's role is to provide a sober second look and advice to the House. So it's very odd, and I certainly hope that Canadians will keep this in mind whenever we go to a next federal election.
Well, as we go to the next topic, what's in my mind is why? Why are they so hung up on this? But we're not going to answer that question today. We're going to move on. We'll talk about C-36. Could you give us a short explanation of what that is and where does it stand now?
So C-36 is called the Online Harms Bill, and essentially it brings back the civil remedy for hate speech. So things that are said online, and of course in an online context, that are said to be inspiring detestation or calumny. So now you can make complaints, and you can even make a complaint to, it's going to be a newly created tribunal created by statute, if you suspect that somebody is going to commit hate speech. So you can apply for a prophylactic order. And this delegates a lot of the responsibilities to platforms. So if platforms don't take down hate speech, which again, I just want to be clear, hate speech, when it exists in cut and dry terms, it's already a crime in the criminal code. Counseling genocide, counseling suicide, those are already crimes. So to some extent, it's duplicative. But if Facebook, if somebody posts a hate speech comment and Facebook doesn't take it down within 24 hours, the fines are 3% of global revenues or up to several millions of dollars, whichever is higher. So these are real fines. And inevitably, what's going to happen, Tanya, is these platforms seeing these fines are going to err on the side of just take everything down. Anything that could be on the edge, anything that we think could provoke detestation of a group, just take it down. So you can already see that it's not just the law that's a problem. It's kind of like the broader specter of the law. It will create a huge chill effect. And we are extremely concerned about this bill at the Canadian Constitution.
Well, and it may very well dissuade many of these companies from doing business in Canada, because who wants to operate within such tight confines? If you said 3% of global profit, I mean, that's huge for a company like Facebook.
Of course. Yeah.
My goodness. Okay, C-26, and again, we're going to unpack this big time with our next guest after the commercial, but give us a primer. What's C-26 and where does it stand?
So C-26 has received, I believe now, its second reading in the House. This is a cybersecurity bill. And so cybersecurity, obviously an incredibly important issue. However, this bill really got the balance between security on the one hand and privacy on the other hand wrong. It allows for the governor and council, as you mentioned in the intro, to tell any telecom company to do or not do anything. Like, it's worded so broadly. But there's also an aspect that as a lawyer, I'm very concerned about, where the bill allows platforms to basically refuse to provide services to people. So something happens and you can't get internet services. And for judicial review, so if you want to challenge that decision, it provides that the government can provide secret evidence as to why that person had their services revoked. So the person themselves, so if I have my services revoked for whatever reason, misunderstandings happen, I don't even get access to the evidence the government has against me.
Wow.
So I don't even have any right of full answer and defense. And normally, and this is kind of drawing from national security hearings, we have a lot of ways to deal with it. And the way we usually deal with it is the court will appoint a security cleared lawyer called an amicus curiae. And that's sort of a fair compromise because it keeps the state secrets protected, but it also allows the applicant to have some right of answer and defense. There's nothing like that here. There's no right of disclosure. There's no involvement of the privacy commissioner. So I'm sure your next guest will get into it, but this is another really sneaky, just full frontal assault on our individual liberties and privacy rights.
You know, I'm in shock and horror hearing what you're saying, Joanna, and you're right. My next guest will unpack it a little bit more, but my goodness, I'm concerned about my freedoms. I continually am. Joanna, thank you so much for joining us. We'll be right back.